Hi, this week we will talk about international personality, and we will continue with international organizations, individuals, and other non-state actors as subjects of international law. For the purpose of this lecture, we will not look at the issue of acquisition of territory, but let's have a brief look at the continuity and change in statehood. First and foremost, reduced effectiveness of government does not affect the entity's statehood, even though from a political view, it may be considered as a failed state. In this regard, we have the example of Somalia since the 1990s. So from a legal point of view, a failed state situation does not automatically negate the statehood. But of course, it is possible for statehood to change in cases of secession, decolonization, merger or unification, as well as dissolution. In the case of secession, the old parent state continues to exist and continues to do so under the same name and with the same legal identity, but with a reduced territory and possibly with reduced population. Some examples are South Sudan's secession from Sudan by referendum, or Bangladesh seceding from Pakistan in the early 1970s. On the other hand, in the case of decolonization, the defining distinction from secession is that former colonies are based elsewhere in the world and not contiguous with the metropolitan area. As in the post-charter period, colonization was considered as evil. Many former colonies gained independence during the 1950s and 60s. In the case of merger or unification, we have an opposite situation. So this refers to a situation where entities which already formed a unity at some point in the history become reunited, as in the example of the unification of the Germanies, or like the merger of South and North Yemen in the 1990s. In the case of dissolution, the expected status is the total breakup of the previous state, with none of the new states continuing the identity of the old state. So practically the parent state dissolves. An example of this is former Socialist Federal Republic of Yugoslavia. An exceptional example is the case of USSR, where there was a total dissolution, but Russia assumed the legal identity of the old parent state. But Russia was accepted as the legal continuation of the USSR. The example of Russia's treatment suggests that political considerations affect the implementation or interpretation of the law on state succession. If we sum up, in the cases where the parent state continues to exist, it means that its treaties will continue in the same manner for the parent state, which applies to the case of Russia and USSR. Whereas in the case of newly independent states as a result of decolonization or dissolution, but not of secession, they can start with a clean slate, a tabula rasa. In cases of merger or unification, the presumption is that the existing treaties continue to remain in force unless the parties agreed for another solution. And as much the same applies to the cases of separation. It is also important to note that state successions do not affect boundary treaties or other territorial regimes. In general terms, a succession of states not only affects treaty relations in general terms, aside from boundary treaties, it also affects such matters as to a state's property, its debts, as well as its archives, which are very important in political terms. Once a state ceases to exist, so does its nationality. Therefore, the guiding presumption is that individuals will have the nationality of the state on whose territory they habitually reside in. So, the former Soviet citizens who habitually reside on the territory of Ukraine, they have acquired the Ukrainian nationality. Or if they lived in Moldova, they would acquire Moldovan nationality. With the succession of states, it's not only the treaties that is affected, but also membership to international organizations. Membership is something personal. So, once a state ceases to exist, so does its membership. And the exception to this is financial institutions such as the IMF and the World Bank, because it is expected that the debts will be assumed by the new states. So in cases where membership is personal, the newly independent states will have to apply to the international organization, such as the United Nations, for membership. If you are talking about a parent state, in the case of secession, their membership status will not be affected, so they will continue as it was before the secession. So in the case of states as subjects of international law, it is important for an entity to have the four components of statehood in order for us to accept it as a state. In this regard, the continuation of statehood or its change affects its legal status in the eyes of international law. Now, let's have a look at international organizations as subjects of international law. As we previously said, although states are still the primary subjects of international law, they are not the exclusive subjects. Among non-state actors, international organizations, transnational corporations, and individuals are afforded a degree of international personality. An international organization, specifically of the intergovernmental type, for the purposes of international law, is an entity established by agreement and which has states as its principal members. In this way, there are open or global organizations, such as the United Nations, enjoying almost universal membership, whereas there are also regional or closed organizations, an example of which is the African Union or the Organization of American States. Depending on the type and membership of the organization, the degree of international personality enjoyed by the international organization varies. Despite the fact that international organizations do not possess a general competence, they are subject to international law. And international organizations are governed by the principle of specialty. That is to say, they are invested by the states, which create them with powers, the limits of which are a function of the common interests, whose promotion those states entrust to them. So, in fact, these organizations are created by states and empowered by states to the limit that they allow them to function. International organizations may have the capacity to own, acquire, and transfer property and to enter into contractual agreements and international agreements with states and other international organizations. They may pursue legal remedies and may enjoy rights and duties under international law, which are basically in the definition of international personality. Every international organization is limited by its constituent charter, such as the Charter of the United Nations in the case of the UN. And this constituent charter is the agreement that establishes the organization. This charter may also expressly provide that an organization is to have an international legal personality, such as the example of Article 47 of the Treaty of the European Union, stating that the EU shall have a legal personality. So personality may only be implied from the constituent document and consolidated through the practice of the organization. As an example of an international organization, let's have a brief look at the United Nations. In the aftermath of the Second World War, the United Nations was established with the aim of maintaining and preserving international peace and security. Currently, with the inclusion of South Sudan, the United Nations has 193 member states. And for these states, the UN Charter functions as the constitution of the community of states. And within its structure, the UN has 6 principal organs, of which the General Assembly is the plenary and the Security Council is the executive organ with legally binding powers. While in the United Nations General Assembly, all member states are represented, in the case of the Security Council, there are 5 permanent member states and 10 non-permanent member states, which are elected for a period of 2 years, representing the world's geographical regions. The United Nations is the only example of an almost universal membership organization. And as we see in the 1949 reparation opinion of the ICJ, the UN had to be considered as a subject of international law. So with these basic features, the United Nations is one of the fundamental examples of an intergovernmental organization, which is very important also for purposes of international law. And as last week we have mentioned, the resolutions of which may give direction to the making of international law. Now, let's move on to a more controversial subject of international law: individuals. Different from states, individuals have limited legal personality, despite the fact that they may possess both international rights and duties. In an exceptional example, under Articles 34 and 35 of the European Convention on Human Rights, individuals can initiate claims alleging breaches of the Convention by their national state. So in this regard, individuals are given the right to bring cases against states before the European Court of Human Rights. But in the case of the International Court of Justice, the ICJ, individuals do not have locus standi, which means the right to bring an action before the court. So, while on the one hand, individuals can enjoy certain rights, on the other hand, individuals can also be held responsible for certain acts or certain conducts, as well as the development of individual criminal responsibility. Today, we can talk about a larger spectrum for individual criminal responsibility, which in the past was simply limited to piracy, and which has for long been accepted as an international crime. But in today's legal system, we can talk about criminal responsibility arising from international criminal law or human rights law. And in general terms, international responsibility derives from international law, and it is independent of the law of any state. So it would not be simply confined to the law of a specific state. And in this regard, we are able to talk about certain duties of individuals and they being subject to international law. Last but not least, we should have a look at other non-state actors. In general terms, non-state actors do not possess international legal personality as a right, but they may enjoy certain rights, defined capacities, as well as locus standi. Some of these non-state actors participate in international life actively and influence the creation and development of international law. In this way, some examples are insurgent groups or rebel groups, indigenous people, national liberation movements, the Holy See, non-governmental organizations, as well as transnational organizations. If you look at insurgent or rebel groups, we see that they are relevant to international law to the extent that they may have de facto control over a certain territory, which means that if the rebel group or the insurgent group takes over the control of the territory and starts to govern this territory, they will assume the responsibility for the actions of the state. Moreover, in the course of civil conflicts, they are bound by international humanitarian law. But they do not have locus standi, and they cannot be considered as responsible as a group for the violations of the group, but individual responsibility still remains. Another example is national liberation movements, a fundamental example of which is the Palestinian Liberation Organization, which used to have a non-member permanent observer status. The Holy See is another notable example of an entity possessing limited international personality. The Holy See has the Pope as the head, has a population which is neither permanent nor indigenous or native, and its function is exclusively religious. but it is a special entity because it is a party to international treaties on diverse subjects such as arbitration, non-proliferation, and monetary matters, and it has a permanent observer status at the UN. In general terms, the Holy See is an anomaly in the international scene, enjoying and exercising international personality. But this is because other international actors are willing to enter into international relations with it. So at this point, the will of states comes into action and allows this entity to have a legal presence in the international system. Then we have the examples of non-governmental organizations, in short, NGOs. These organizations seek to achieve diverse aims, from the protection of specific human rights and humanitarian needs to the environment, animal rights, religious interests, vice versa. But their common characteristic is their non-lucrative nature. In other words, they are non-profit organizations. They are entities of municipal law, in other words, domestic law, and they are created under the law of a particular state, but many of them act in a global way, extending their activities transnationally and considerably influencing the public opinion. One example is Greenpeace. NGOs do not have an international legal capacity, though they enjoy consultative status before international organizations. A special example in that regard is the International Committee of the Red Cross. And the reason is that it has the capacity to conclude agreements with states and has been given certain competencies by the 1949 Geneva Conventions. In addition to non-governmental organizations, which we said that they are of non-profit nature, we have the profitable ones, which are transnational corporations. Different from the other non-state actors, transnational corporations enjoy considerable power due to economic reasons. They negotiate with governments, and some even enjoy economic power which may exceed that of states. And in general terms, the scope of their activities transcend national boundaries. So in that regard, they can be quite influential in the international scene. And their transnational activities place them within international law. Well, this concludes the brief overview of subjects of international law. In our live session, we will talk about these subjects in more detail with examples. So please complete your reading assignments and take note of your questions, and I will see you in the live session.